Law Maxims, Doctrines and Principles. Part 1 by Amicus Curious. Number 1. Ignorantia legis non excusat. What it means. Ignorance of the law excuses no one. A person cannot plead ignorance of the law as a defense. This ensures uniform application of laws and prevents selective compliance. That's ignorantia legis non excusat. Number 2. Dura lex sed lex. What it means. The law may be harsh, but it is the law. Courts must enforce the law even if its application is severe. It underscores the supremacy of legal rules over personal sympathy. That's dura lex sed lex. Number 3. Actus non facit reum nisi mens sit re. What it means. No crime without a guilty mind. Criminal liability requires both a wrongful act and intent. This protects individuals from punishment for purely accidental acts. That's actus non facit reum nisi mens sit re. Number 4. In dubio pro reo. What it means. When in doubt, rule in favor of the accused. Ambiguities in criminal cases must favor the accused. It safeguards the presumption of innocence and prevents wrongful convictions. That's in dubio pro reo. Number 5. Res judicata. What it means. A matter already judged cannot be relitigated. Final judgments are conclusive between the parties. This prevents endless litigation and promotes judicial stability. That's res judicata. Number 6. Res ipsa loquitur. What it means. The thing speaks for itself. Negligence may be inferred from the mere occurrence of certain accidents. This shifts the burden to defendants to explain unusual harm. That's res ipsa loquitur. Number 7. Stare decisis et non quieta movere. What it means. Stand by decisions and do not disturb settled matters. Courts follow precedent to ensure stability. This promotes consistency and predictability in constitutional interpretation. That's stare decisis et non quieta movere. Number 8. Salus populi est suprema lex. What it means. The welfare of the people is the supreme law. Public interest overrides individual claims when laws are interpreted. This principle justifies state action during emergencies or crises. That's salus populi est suprema lex. Number 9. Pacta sunt servanda. What it means. Agreements must be kept. Contracts are binding and enforceable between parties. This principle ensures stability in commercial and civil transactions. That's pacta sunt servanda. Number 10. Nemo dat quod non habet. What it means. No one can give what he does not have. Ownership cannot be transferred by someone without title. This protects property rights and prevents fraud. That's Nemo dat quod non habet. Number 11. Lex specialis derogat generali. What it means. Special law prevails over general law. Specific provisions override general ones when both apply. This ensures that specialized statutes are given priority. That's lex specialis derogat generali. Number 12. Lex posterior derogat priori. What it means. Later law repeals earlier law. Newer laws supersede older conflicting ones. This maintains coherence in the legal system. That's lex posterior derogat priori. Number 13. Expressio unius est exclusio ulterius. What it means. The express mention of one excludes others. Enumerated items exclude those not listed. This limits interpretation to what lawmakers intended. That's expressio unius est exclusio ulterius. Number 14. E justem generis. What it means. Of the same kind. General words are limited by specific enumeration. This prevents overly broad application of statutes. That's e justem generis. Number 15. Doctrine of operative fact. What it means. Unconstitutional laws may still produce valid effects before nullification. Recognizes the practical consequences of a law before it is struck down. This prevents injustice to those who relied on the law. That's doctrine of operative fact. Number 16. Doctrine of primary jurisdiction. What it means. Courts defer to agencies on specialized matters. Administrative expertise must be respected. This ensures technical issues are resolved by competent bodies first. That's doctrine of primary jurisdiction. Number 17. Doctrine of exhaustion of administrative remedies. What it means. Parties must exhaust remedies before going to court. Prevents premature judicial intervention. This promotes efficiency and respects agency processes. That's doctrine of exhaustion of administrative remedies. Number 18. Doctrine of state immunity. What it means. The state cannot be sued without consent. Protects sovereignty from undue interference. This ensures government functions are not hampered by litigation. That's doctrine of state immunity. Number 19. Doctrine of parens patriae. What it means. The state acts as guardian of the helpless. Justifies state intervention for minors, mentally ill, or disadvantaged groups. This reflects the government's protective role. That's Doctrine of Parens Patriae. Number 20. Doctrine of piercing the corporate veil. What it means. Courts may disregard corporate personality to prevent fraud or injustice. This allows liability to extend to shareholders or officers when the corporate form is abused. It ensures corporations are not used as shields for wrongdoing. That's Doctrine of piercing the corporate veil. Number 21. Hernandez Doctrine. What it means. Common crimes are absorbed in rebellion. Rebellion cannot be complexed with murder or arson. This prevents the state from multiplying charges against political offenders. That's Hernandez Doctrine. Number 22. Political Offense Doctrine. What it means. Common crimes committed in pursuit of political crimes are absorbed. Protects political offenders from multiple charges. It recognizes rebellion as a political act rather than a common crime. That's Political Offense Doctrine. Number 23. Doctrine of Conspiracy. What it means. Agreement to commit a crime makes all liable. Conspirators share liability for the crime regardless of individual acts. This emphasizes collective responsibility in criminal law. That's Doctrine of Conspiracy. Number 24. Doctrine of Continuing Crime. What it means. Certain crimes are considered continuing until consummated. Offenses like illegal possession of firearms or kidnapping persist until resolved. This affects jurisdiction and prescription periods. That's Doctrine of Continuing Crime. Number 25. Doctrine of Self-Defense. What it means. Reasonable force may be used to protect oneself. Liability is excused when force is necessary to repel unlawful aggression. It balances individual safety with proportionality in response. That's Doctrine of Self-Defense. Number 26. Doctrine of Mitigating Circumstances. What it means. Certain factors reduce criminal liability. Age, passion, or voluntary surrender mitigate penalties. This ensures fairness in sentencing. That's Doctrine of Mitigating Circumstances. Number 27. Doctrine of Aggravating Circumstances. What it means. Certain factors increase criminal liability. Nighttime, cruelty, or abuse of confidence aggravate penalties. This enhances punishment for more blameworthy acts. That's Doctrine of Aggravating Circumstances. Number 28. Doctrine of Complex Crimes. What it means. A single act producing multiple crimes is punished more severely. Applies to homicide with robbery, etc. It prevents offenders from escaping liability by fragmenting acts. That's Doctrine of Complex Crimes. Number 29. Doctrine of Proximate Cause. What it means. Liability attaches to the proximate cause of injury. Criminal liability follows the chain of causation. This ensures accountability for foreseeable consequences. That's Doctrine of Proximate Cause. Number 30. Doctrine of Conspiracy by Silence. What it means. Silence or acquiescence may imply agreement in crime. Passive participation can still incur liability. This broadens accountability in group crimes. That's Doctrine of Conspiracy by Silence. Number 31. Doctrine of Indeterminate Sentence. What it means. Sentences must have minimum and maximum terms. Provides flexibility in parole and rehabilitation. It balances punishment with reform. That's Doctrine of Indeterminate Sentence. Number 32. Doctrine of Probable Cause. What it means. Criminal charges require probable cause. Prevents arbitrary prosecution. This protects individuals from baseless charges. That's Doctrine of Probable Cause. Number 33. Doctrine of Custodial Investigation. What it means. Rights attached during custodial investigation. Ensures Miranda rights are respected. This protects suspects from coercion. That's Doctrine of Custodial Investigation. Number 34. Doctrine of Fruit of the Poisonous Tree. What it means. Evidence obtained illegally is inadmissible. Protects constitutional rights. It deters unlawful police conduct. That's Doctrine of Fruit of the Poisonous Tree. Number 35. Doctrine of Chain of Custody. What it means. Evidence must be properly documented. Ensures integrity of seized items. This is crucial in drug cases. That's Doctrine of Chain of Custody. Number 36. Doctrine of Corpus Delicti. What it means. Proof of crime requires evidence of its occurrence. Prevents conviction without proof of crime. This safeguards against wrongful punishment. That's Doctrine of Corpus Delicti. Number 37. Doctrine of Alibi. What it means. Alibi is weak unless proven with certainty. Courts view alibi with suspicion. It must be airtight to succeed. That's Doctrine of Alibi. Number 38. Doctrine of Flight. What it means. Flight indicates guilt. Evading authorities suggests consciousness of guilt. This is circumstantial evidence. That's Doctrine of Flight. Number 39. Doctrine of Entrapment versus Instigation. What it means. Entrapment is allowed, instigation is not. Entrapment catches criminals, instigation creates them. This distinction protects fairness. That's doctrine of entrapment versus instigation. Number 40. Doctrine of continuing rebellion. What it means. Rebellion is continuous until suppressed. Liability persists while rebellion continues. This affects prosecution timelines. That's doctrine of continuing rebellion. Like and subscribe to Amicus Curious for more law school and bar exam related videos and shorts.